deal with protesters.
It feels good coming to the courts knowing you ain't got no warrants.
Not part of my group.
That's true freedom, ain't it?
So, Bill, we just had another pretrial hearing for Shannon and Catherine's cases, right?
We did, and we're still conducting the motion hearings on our discovery on selective prosecution by the Suffolk County District Attorney's Office, and the court has substantially granted our discovery request. We had to sort that out today. We also filed an interim summary of the work that we've done thus far without receiving any discovery from District Attorney's Office. And the totals on that are remarkable. We've surveyed 114 protester cases, not involving protests against Mayor Wu or the vaccines, but involving popular leftist causes such as race issues, LGBTQ issues, climate change issues, and the Palestine dispute. The rough totals out of those 114 cases are 94% of the felonies have been dismissed and 100% of the misdemeanors have been dismissed. That's 73 misdemeanor cases, each and every one of them dismissed. For the small group of protester cases who are protesting the vaccines and Mayor Wu, and I represent 5 of his clients, there are some others out there, each and every one of them has not been dismissed and has been the subject of full-bore prosecutions by the District Attorney's Office. So this is either one of the most remarkable coincidences in the history of mankind, or there's a design, there's a policy behind this, one that is extremely prejudicial to people with viewpoints that don't agree with the politics of the mayor and of the district attorney for Suffolk County. And that's what we're going to continue to explore. We're not satisfied with the 114 cases. We're going to keep on building on that number. It's a lot of hard work and researching it, but we're going to get an even more representative total. And we're not cherry picking. We're taking every single protester case that we can find and compiling data on. Another issue that was discussed today was that the district attorney was trying to revisit the issue of our ability to get discoveries for selective prosecutions, claiming that this really wasn't an equal protection case, that Massachusetts law didn't support it. We cited some law to the contrary, and I don't think that the court is going to accept that very desperate argument at any point in time. It'll get obviously hashed out in a motion hearing in the future. The law is very well established. Equal protection law doesn't just protect people of different races and religions and national origins and sexes and genders and gender choices. It also protects, in the context of criminal prosecutions, people with dissenting viewpoints. And to weaponize the legal system against people based upon their political leanings is unfair to everyone. It is as un-American a practice as we can possibly imagine, and that's what we're addressing.
Amen. I think one of the highlights from today that I'd like you to speak to is regarding the position that the Boston Police does not have the master list of Mayor Wu protesters.
Yes, what started this whole inquiry off, at least for us, was the inadvertent disclosure of what has been come to be known as Mayor Wu's enemies list. That was an email that originated from City Hall with a list of names on it, who just turned out to be the protesters against Mayor Wu, who were targeted for law enforcement activities, including my clients here standing behind me and a number of others. The other email, which was produced in response to a FOIA request from Judicial Watch, is an internal police email discussing procedures for dealing with the city ordinance that was passed to protect Mayor Wu at a residence from any protest activity there. It makes reference to the police maintaining, quote, master list of protesters. We want that list. We've asked for that list. They're trying to claim they can't find the list no longer exists. Right within the FOIA response, that email, it shows that that email was CC'd to 29 police officers, most of them sergeant level or above. And that means that, well, they never got it either, and there's no email chains. Then the district attorney is trying to claim, well, we have no way of searching those email chains, as if governmental entities don't comply with FOIA requests all the time. So we're going to keep pushing on that issue. It's a hot button issue. It's not the heart of our case, but it's part of our case, and we deserve to have our day in court and to be able to submit our proof and gather and harvest the evidence that's out there. And that's what we're very much involved and committed to doing.
Is this not a further issue of destroying or deleting evidence?
It could be. I can't say for sure what's happened to this evidence. I can say that I'm hardly persuaded or convinced by the explanations that we've been provided thus far. So we'll just keep pushing. That's what we do.
Thank you very much.
Thank you.
What? All rise, please. Mr. Jennings, client, please. Court's in session. You may be seated.
Good morning, Your Honor. Good morning, everyone. Today is January 5th, 2024. This is the West Roxbury Division of the Boston Municipal Court, third session. The Honorable Judge Coffey presiding in the matter of the Commonwealth versus Shannon Llewellyn, docket number 2206CS0593, and Catherine Vitale, docket number 2206CS0590.
Good morning, everyone, and welcome.
Good morning, Your Honor.
Morning, Your Honor.
Parties identify themselves, please, for the Commonwealth
Morning, Your Honor. Eddie Maxwell Revenue for the Commonwealth.
and for both defendants.
William Gens for the defendants. Good morning, Your Honor.
Good morning. So today's hearing is a continuation regarding discovery requests that have been made by the defendants. The last time we were in court, the defendants had filed memoranda regarding specific requests. And the Commonwealth wanted an opportunity to respond to the written arguments that were presented. At the last date, the defendant's attorney also had...
Oh, I'm sorry, sir. I don't mean to do anything. I just want you to know I'm here to play communism. That's all.
All right.
Have a seat, please.
Please have a seat, sir. So at this point, I'll give you an additional opportunity to expand on your arguments, and then I'll also hear from the Commonwealth.
Okay, just as a housekeeping matter, we did file, we mentioned the last time, filing a summary at this stage of where we are in terms of the statistical compilation, and I hope the court received that. It was filed in hand on Wednesday,
Wednesday of...
this week. was filed with the clerk's office and served in hand upon the district attorney's office.
Okay.
Do you indeed have it, though?
I have it, but I haven't, it wasn't brought to my attention, unfortunately.
Okay.
But please, go ahead.
In any event, that basically gives us, gives a summary of where we are, we being the defense, in 3 respects. And one is the overall statistics that we've compiled thus far, and of course documented by docket sheets and news reports and the like. And we've thus far surveyed 114 cases.
And is that based on the?
That entire pile that's in front of you, yes,
That I
indeed.
did review. Because that
Yes,
was
but
previous.
what that didn't have, and I think it was confusing for the court and for everyone, was any type of summary of where we are so far. I'm obviously not done, but it does, the first thing it does is it summarizes the prosecutorial efforts with regard to those protesters who are in the various categories of race and climate change, LGBTQ, Palestine. The second thing that it does is his analysis, what the court raised, and I'm glad you raised it, of the community service dispensations that were administered, and there's a statistical breakdown of that for the court's consideration. And I think that that's a very relevant and valid issue. And the third thing that it does is it at least mentions, for what I'm calling the targeted protesters, people who are on that enemies list that we submitted to me, and that there is the most incomplete. And obviously we wanted to explore the so-called master list of protesters. Now I've received a piece of discovery notice today, basically claiming that the police don't have the master list of protesters, and that's highly problematic because the email that was part of the Judicial Watch FOIA response mentioning and highly prominently directing all the recipients to the master list of protesters was sent to 29 different police officers. They're all here in the CC part of this. I can't say for sure, but I do know that all of the names that I recognize are
This is the email that Officer Darren Greeley sent? Is that-
precisely.
All right.
And the recipients, and I haven't run this down totally, but the ones that I recognize were all ranked sergeant or above. These are supervising officers. The Commonwealth's notice of discovery, which is based upon a response from the Boston Police Department's Office of the Legal Advisor, basically says that they don't have a master list of protesters, do not believe that one exists, and believe that the master list of protesters refers to the collection of booking sheets of those arrested and copies of the hearing applications for those summons in connection with alleged violations of the City of Boston ordinance against targeted protesting. The problem is, Your Honor, that that email from Greeley is dated April 4th, and there were no arrests taking place at all. I don't even think the ordinance was in effect then. In other words, the master list preceded the ordinance. And for them to take the position that, this is all we have, would mean that nobody on this list, none of the 29, ever asked for the master list of protesters. Or if they did, that somehow the email transmissions of those were all lost, or they weren't transmitted by email, but everybody who received it somehow lost it. I think that further discovery is warranted regarding the email transmission of that master list.
Don't you have a burden to establish the relevance under Rule 14? I think you're jumping a step. someone is on the list for protesting does not necessarily mean that those individuals have been arrested for the same crimes that those two clients have been arrested.
Well, yes, that's the case. What I'm trying to do here is, I mean, my overall effort is showing a differential treatment across the board between protesters for certain causes versus protests of other causes. It seems to me that the only fair reading of this master list of protesters is against protesters against Mayor Wu. Now, I have the enemies list, but that comes from someplace else. That comes from the mayor's office. Now, the police work for the mayor, that's true, and she names the commissioner, etc. But this master list of protesters would yield any number of people, not necessarily on the enemies list, but what the police compile.
Let me hear from the Commonwealth about whether or not this list actually exists. And your answers to confirm that.
Thank you, Your Honor. So I recounted the explanations and answers that I've received from officials in BPD when I've inquired about the existence of the list referenced in the email from former Captain Greeley. Now, my understanding is that we received a packet of the booking sheets and application for clerk's hearings for individuals arrested in connection with the targeted protesting ordinance. I do take defense counsel's point that those would have potentially post-dated the email from the former captain. However, at this point, I really can't do anything more than to report what is told to me when I inquire with people who would know the answer to these questions. And what the Office for Legal Advisor and a sergeant at District E5 told me is that they do not have a master list of protesters. And the closest thing to that would be the grouping of individuals who were arrested contemporaneously with the two defendants in these joint cases, which I believe defense counsel received because I believe I did see a list of names in a previous filing. If that's incorrect and defense counsel hasn't received those, then I'm happy to provide them. But that's my understanding.
I have not received what he's referring to. I do have the enemies list, but I haven't. That's the only list I have.
And that may be the same thing. So what I can do is follow up with the sergeant I spoke to at District E5 and just ask him to re-provide those materials.
Okay. And when you say
Why is it a sergeant?
legal advisors, that's for the Boston.
For the Boston Police Department.
Why is it a sergeant?
Boston
He's the
Police
lowest
Department specifically.
rung on that.
For Boston Police Department, not for the city of Boston.
Okay.
So again, happy to continue making efforts to get to the bottom of whether or not this master list exists, and if it truly is just these individuals amongst those referenced by the sergeant in my most recent communications with him. Happy to provide what materials we can relative to that.
I know what to do.
With regard to defense counsel's other requests for discovery, again, I think what defense counsel is advancing is something that could be termed a selective prosecution claim, but it's not under the equal protection provisions of the Massachusetts Declaration of Rights. It's actually under the First Amendment, because it seems to be that he's alleging that people have been treated differently by the police and by the Suffolk County DA's office, not on the basis of individual characteristics, but on the basis of their viewpoint. It's a viewpoint discrimination claim, which is a basis for potential dismissal prior to trial in a criminal case if one transposes the relevant federal line of precedent to Massachusetts law, which I think is appropriate given that the Constitution obviously still applies. There isn't a lot, really any, that I could find Massachusetts case law on point. If defense counsel is advancing a request for discretionary discovery under Massachusetts Rules of Criminal Procedure 14A2, there's the Laura line of case law that says under an equal protection selective prosecution claim, you're entitled to certain information potentially that could help build a statistical profile showing similarly situated people were treated differently on the basis of an individual characteristic upon which the government cannot permissibly discriminate. But there is no comparable line of case law saying that such discovery is potentially available under 14A2 if the basis is a free speech First Amendment viewpoint discrimination claim. So for that basis, Commonwealth would argue that there isn't grounds to allow defense counsel's additional requests for discovery.
Specifically, what are you referring to?
Specifically, there was in the...
Let's talk concretely in terms
Of course.
what's being asked and what has been provided and what the Commonwealth is referring to.
So-
Request number 2.
Right, precisely.
For each of the persons on the list of 210, 2022, and that we can all be attorney is this so-called enemies list, correct?
Number 2,
Referenced in the email of April 4th. All information evidencing the prosecution by the Suffolk County District Attorney of those individuals, including charges, docket numbers, police reports, and case status disposition.
yes.
So, yes, we're objecting to that. I think there are multiple grounds. One, that there isn't necessarily that same type of precedent supporting a right to such discovery under 14A2 if it's a First Amendment claim. Additionally, I would argue that it's overly broad. The crux of the type of viewpoint discrimination claim that I think defense counsel is alleging is that people who committed the same crime under the same circumstances were treated differently on the basis of some type of politically salient viewpoint that they held. And obviously that's impermissible under the First Amendment. Here, though, we have no evidence that there were people with a certain viewpoint who committed the crime of disturbing the peace under the same circumstances as the defendants here. There's no evidence that, well, I should rephrase that. There is evidence that there are other people who did commit the same crime under the same circumstances, but there's no evidence that they held a particular viewpoint that was contrary to a viewpoint held and expressed by the defendants, let alone that that was the cause for any type of differential treatment. References to protests for other cause under other circumstances, I think, fails to accurately appreciate the first element of a First Amendment selective prosecution claim, which is that similarly situated people were treated differently. And again, there isn't a lot of Massachusetts case law on it. However, I did find what I thought was a very instructive and persuasive case that the District of Columbia Circuit decided back in August. That's Frederick Douglass Foundation, Inc. versus District of Columbia. And the citation is 82 F. Doc 4th, 1122. That case really delineates the differences between...
Say the name of the case again.
Oh, yes. It's Frederick Douglass Foundation, Inc. versus District of Columbia. That case really delineates the differences between a selective prosecution claim under equal protection principles versus one under First Amendment principles. And it explicitly states that they are doctrinally and substantively different claims with different elements. And for that basis, I do not believe that it's.
Does it discuss discovery? Does it?
It does not discuss discovery, unfortunately. However, I think it is instructive because it shows that it's inappropriate to take Laura, which is the seminal case regarding a potential available discretionary discovery under our rules of procedure under the analogous equal protection provisions of our state constitution, and then transpose that and apply the same standard to a selective prosecution claim under the First Amendment. Again, doctrinally different, different elements. Here, again, it's about similarly situated individuals. There are just too many different potential confounding variables, alternative explanations, if you're comparing apples to oranges to bananas, which is what defense counsel is trying to do by comparing his clients to protesters for LGBTQ issues, to protesters for climate change issues, etc. The focus needs to be more narrow and needs to eliminate other potential confounding variables by looking at similarly situated individuals. And here there's no evidence that there were other people who had viewpoints different from the defendants who engaged in targeted protesting in a residential area in the city of Boston around the same time, and in so doing disturbs the peace within the meaning of that criminal statute. So at this point, Commonwealth's position is that this discovery is not relevant. It's not something that's necessarily allowable the defendants are entitled to under Laura. Much of it is publicly available, especially a search on mass courts, for example, could reveal a lot of this information. And ultimately, there just isn't any type of underlying initial showing to establish that threshold relevancy for the requested materials. It is required for 14A2 discretionary discovery.
Okay. Do you want to respond?
I do. With regard,
We're just talking about,
I know the discussion
It's one of
segued.
our very loquacious, and I enjoy listening to both of you argue. However, let's get to the heart of the matter, okay? And the heart of the matter has to do with your requests, number 2 and number 3. That's what we need to look at this morning.
And number 1, because I don't think we finished really discussing that.
I think we did.
We segued into equal protection from there.
Let's do 2 and 3, okay?
Okay.
And then if there are others that you want to expend upon,
If
that's fine.
if I may,
But in terms of 2, I'll hear you, and then I'm going to share with you my thoughts. Go ahead.
okay. May I just briefly respond to the equal protection issue that was raised?
Yes.
I think that is a highly constricted view of a selective prosecution analysis. Let's use the Frederick Douglass case as an example, because it's an excellent case coming out of a very unlikely court, the D.C. Circuit Court of Appeals. What happened down there was that the D.C. Administration, the mayor's administration, allowed a group to write Black Lives Matter in huge letters all across the main avenue there. And when a group protesting an entirely different thing wanted to write unborn Black Lives Matter, they were protesting abortion, the D.C. authorities came down on them and prosecuted them criminally. 2 different subject matters, similar type of protest means, but it wasn't apples and oranges. It was clear, outright viewpoint discrimination. The district attorney has asserted that there's no evidence of what the viewpoint was for these protesters that we're complaining about. And I would submit that the materials that we've filed with the court show abundantly what the viewpoint was. For the people who went into the State House and pulled down their pants, their message was written on their butts. For the other people, you can read the signs that they were carrying and showing them shutting down the substation in East Boston for climate change reasons, for being against the Palestine conflict by blocking the Brieux Bridge during rush hour for 2 hours and gridlocking the city. I would submit that the crimes don't necessarily have to be, or the charges don't have to be the same. Obstructing traffic with dragon's teeth, those iron drums with chains, in the name of climate change, is far more excessive than a garden variety disorderly conduct charge. And when those people all get dismissed, their cases with or without community service, while people who are just charged with disorderly conduct get the full weight of the prosecution of the state, that's problematic. That undermines any reasonable treatment of equal protection. And whether we're talking equal protection or the First Amendment, abundant case law makes it incumbent upon the states. They're incorporated. I think the only amendment that isn't is the Seventh. So there may be a dearth of law in Massachusetts on this issue, but there's plenty elsewhere, and when the time comes, when we do finalize what we're doing in a motion to dismiss, we will definitely collect it all for the court's consideration because it supports our point of view. Now, to get back to the discovery.
Right.
Okay.
The specific request.
I just want to say with regard to the master list, there's two ways that we can do this. One is that I have to go and start doing FOIA requests, follow-ups to get the email chains.
The master list isn't referenced in 2.
Okay, you want to start with 2? I'll start with 2.
I want to start with 2.
Okay.
Please.
Yeah, here's the problem that I'm having with 2, and I articulate.
2 is the enemies list.
Understood.
All right.
And the problem I'm having there, and it's only a slight problem because I represent half the people who are on that list, and I know their cases, so I'm not looking for that. But I've got people on that list who are either described with what appear to be nicknames or pseudonyms or partial names. A woman with the last name of Thui who was arrested before. I don't know who that is. Now, somebody in the mayor's office or the police, or both, does know, or at least attempted to find out. That's what I'm looking for. I've got somebody named Karina Lucene. I can only guess who that is. Other people on that list. And if they're maintaining lists like this, it must be backed up by something, whatever it is. That's what I would like. I don't have it. I have no way of getting it or burrowing into the archives of the police or the city council other than a general FOIA request, which I think is not really appropriate to put that burden on me when we're in the context of a legal proceeding where the court can simply order it. It's relevant. Remember, I'm trying to show 2 sides here, and where I'm incomplete is my own side. I have plenty more to do with what the prosecution has done. It's tedious, expensive work, but we'll do it without complaint. Now, as far as 3 goes.
No, let's do 2.
Let's do 2.
Let's do 2, and I'll tell you my decision. So, did you want to respond to what he just said?
I still think fundamentally the issue I'm having is a threshold showing relevancy, because we don't have identifiable groups of people or an identifiable group of people who had a viewpoint different from the defendants.
But I think we have to keep in mind that we're talking about discovery. And the fact that something is discoverable doesn't necessarily mean that it's admissible. And what weight the court would give it to buttress or to support a motion to dismiss based on selective prosecution. So I think that that's what needs to be kept in mind. So this is what my decision is with regards to request number 2. I do think, Attorney Janice, that your point is well taken in terms of the aliases or pseudonyms that the list includes, because clearly you would not be able to identify or properly look at the history of someone named Korean Hussein. So I am going to request that the Commonwealth go to the police and ask them, instruct them, that they need to give the proper name, that, because these, not the slang, not the aliases. The second part of my decision is as follows. I think your request is too broad. So once you get that list of which identifies the people by their proper name, then I think the Commonwealth needs to inform you of any of those individuals who have been charged with disturbing the peace. The same offenses that your 2 clients are doing.
If I have the names, I'm where I need to be.
All right. It's not the name. So that's my decision on number 2. So now let's go on to number 3.
And just so I make sure that I have the right list of people, that would be the
Exhibit
so-called
2.
enemies list
Yeah,
from the September 25th motion.
exactly.
Okay, we good?
Yes, and I have it in a number of different formats, whatever you'd like,
We're
we'll
not
give to you.
good. Number 1 is not addressed. We're not good.
I'm sorry.
No, we're not done with number
Could
1.
you explain to your clients that you are representing them in issue?
Yeah, we need to, pass me a note if you have something to say, okay? We're good.
All right, thank you.
Um,
All right, now let's talk about number 3.
Now, number 3, Your Honor, there was an issue of whether that was overly broad. And I submitted to the prosecution and to the court a proposed narrowing of that request. I haven't gotten a response whether they agree, disagree, or agree in part and disagree in part.
So what is, I have how it reads originally. All other communications, apart from the emails referenced above, 2 are from the Boston Police, Suffolk County DA's office, and any member of Mayor Bruce's administration regarding the treatment, arrest, and prosecution of political protests.
And we narrowed that, and
Now you have offered a modification.
I believe I filed it with the court, but I have another copy here, and the modified proposal.
For the period January 2022?
Exactly. So that it narrows it in terms of time, and it also, if you go to the next page, defines the type of political protests that we were seeking.
This is the second time, sir, that you shouted out in the courtroom. You're in a courtroom. I'd like you to be able to stay, but I'm not going to tolerate people shouting out. You have a larger population of people. They want to identify everyone protesting. You to leave.
Okay, I'm sorry, Your Honor. I just haven't discovered.
All right. What did you say, Attorney James? I'm sorry.
Okay, I think you have the document, and our revised request flows over into the next page, and I narrowed down the term political protesters so that it would cover the issues that we're seeking. Now, I think January 2022 to the present is definitely manageable. I've been digging deeply into that period, but I'm approaching it from a different angle. I have to go through news reports and public records and docket sheets. The district attorney's office, I'm hopeful, if not confident, has their own files that are organized in a certain way. I'll suggest that the overall trends of dismissals of each and every misdemeanor level protester in these categories for the last 2 years suggests that it's not happenstance or chance. There's some organized, conscious design involved, which would mean that it's reflected in their files. If they're going to say no, they don't have it, I'm content with it because it forms part of my argument. But that's essentially my proposed narrowing of it. If the court thinks it should be narrowed further, I'll certainly weigh in.
So I'm not clear, for the period of all communications apart from emails, so what type of communications are you talking about? You're talking about conversations that need to be,
Here's
you're talking about documents, communications is rather broad.
it is broad, and I can define it. Essentially, it was pure dumb luck that we got this enemies list and this FOIA request from Judicial Watch in the first place. They were not asking specifically for this type of communication, and I am. In other words, if there are any communications between the district attorney's office, the police department, and or the mayor's office regarding policies towards protesters of any sort, that I think would be highly relevant to our inquiry, because one of the things that I have to show is intent. And I have plenty of intent evidence already, but I'd like more. The intent evidence I have is indeed public statements from this district attorney's office condemning, for example, people who are protesting Mayor Wu, saying they have no place in our society, unlike other legitimate protesters, obviously, who are populated by the climate change, LGBT, and other issues that he has also issued public statements expressly and strongly endorsing. So it's no surprise to us that all the climate change protesters' cases have been dismissed. All the LGBTQ have been dismissed. We know where he stands, but I'd like to see whether there's just documented communications that also buttress that potential possibility that he's working in league with Mayor Wu in her enemies list, etc. I mean, certainly the statistics are, I think, support me thus far, and we'll continue to dig out these cases. As I said to you once before, I'm not curating them. If I find one that doesn't, I'm not curating them. In other words, I'm not overlooking anything. I'm taking them all as they come.
So the only way that we would be able to identify any such communications, in theory, would be through some type of email records search. I reached out to our IT department to ask them how onerous that would be, based on the search parameters contained in the revised version of request number 3. And my office is still trying to figure out the answer to that question.
It's too court.
I personally have not had a case where such discovery was ordered. I don't know if we have the type of software to do that. We very well may. I just don't know the answer to that question, and that's what we're trying to figure out at this point. For example, if it's something that we could just do if they're email archives and we have software that allows us to do just a keyword search and then allows us to further filter and narrow results in order to fit the parameters of the request, it potentially could be something relatively simple to do. I don't know how long it would take, but the actual
Okay.
action is not particularly complicated. But again, I don't know to what extent my office has that technology.
Let me tell you my concern. Your request is broad, overly broad, but I think that part of it has merit. I mean, I do think you're entitled to know if there was a policy or some decision to treat that whole COVID vaccine, residential picketing, whether a policy was put in place. Because at some point, folks were being just summoned in for a person. And then that all changed. And then people were being arrested. And the cases were going forward. So I do think that there is, and probably a strong likelihood that someone made that decision, whether it was the mayor's office or whether it was the police. At this juncture, I wouldn't want to speculate. But I think your request is reasonable on that ground. But in terms of all the other political protests, it's too broad. It's too broad.
If I may just say this, I'm very skeptical of the idea that the district attorney's office or any other political branch doesn't have the mechanisms to comply with what essentially would be the same as a FOIA request. They do it all the time. They have means of searching through their emails and using keywords and the like. So I am not going to necessarily be...
Okay, well, so why don't we do this? Why don't, I would suggest that Commonwealth follow through with the court's decision, and then once you receive those materials, if it warrants further discussion, then I'm always open for you to file requests
Yep.
to revisit the issue. But at this juncture, I'm going to limit it just to the issues involved in this case. That being protests concerning the vaccination for COVID.
Yeah, I mean, I can live with that. That's the heart and soul of what I'm looking for.
Right.
So we've done 2 and 3, but I don't know that we've really landed anywhere on number 1.
That's not the only issue.
Number one, I'm happy to continue following up on.
She gave me what I wanted. So the Commonwealth will follow up on that as well. So it's 1, 2, and 3. I will say that the court did, well, by agreement, we did 5 and 6, and the court allowed 8. We knocked out 7. And I don't have anything on that yet, so I'm expecting that the Commonwealth will diligently attempt to satisfy those by the next date.
What day would you like then, please?
Can we stay with Fridays? It seems to work out pretty well.
And I'm sorry, just to that last point, those last requests. So request number 5, 6, and 7.
5, I have that was by agreement.
Yeah, 6
Right.
by agreement and
And-
7 by order of the court.
I did previously,
6 was also agreed upon. 7 was denied.
Yeah, I'm sorry, I meant to say 8 was allowed.
I'm sorry.
8 was allowed, not 7. I misspoke.
Right.
Yeah.
I did file a notice of discovery regarding request number 5.
Okay.
And then request number 8, I represented that the discovery does not exist.
Well, if the Commonwealth could just simply respond in writing to those, that would satisfy
Sure,
my
I
needs.
can file notice of discovery, and that's standards, policies, practices, or criteria, right?
Exactly.
Okay, yeah, happy to do that in a notice of discovery.
All right. What's a good date for you to go?
Can we use February 23rd? It's a
If
Friday? No?
that is anything similar, I might be not Wednesday, probably.
That may not be good for you.
No, I might not be in the state. Is there anything
Okay.
before?
Can we do, I can do a Thursday. I'm sorry, I can do the 16th. Is the 16th okay? Of February. One of my clients is out of the country on the 23rd.
Does that give the Commonwealth enough time? February 16th?
I think it should.
A little more than a month, that's fine.
Okay then.
Your Honor, may I address the court?
No,
Sir, be quiet, please.
Sir, you're in a court of law. Please. I want you to be able to stay observant, but it's not a participatory exercise. Thank you.
I'm a taxpayer.
I know you are, sir.
I have the right to speak. Are you
Not
enforcing
in the
law?
court of law. I'm going to ask you to leave now.
Your Honor, if I may just approach just to file our
Related to
related
voice? Or maybe it's the image.
and the notice of discovery that we filed today with respect to the master list of protesters.
I love Jesus Christ. I don't. You gonna force me out?
All right. And you gave the Attorney General a copy?
I have that, Your Honor.
Yes.
And just for the record, that gentleman who's been escorted away has no connection whatsoever to me or my clients, okay?
February 16th, we decided?
Please. All right. Anything else to discuss at this point, gentlemen? You good?
Thank you, Your Honor.
Commonwealth's perspective.
Thank you all for your patience and your courtesy.
In the Commonwealth versus Shannon Llewellyn, docket number 2206, CR0593, Catherine Vitale, docket number 2206, CR0590. You reach release to the same terms and conditions for your appearance on February 16, 2024, at 9 a.m. for pretrial hearing. Good luck.
My name is Joe, and I'm on that list.
Thank you, Your Honor. Thank you, Mr. Clark.
Court all
Thank you,
right,
counsel.
please.
Thank you.
My name is Joe Lavina, and I'm on that list, and I've been arrested for disturbing the peace 3 times. Okay, so you make sure they give you my information. I'm on that list. Okay. They're doing the same stuff they're doing to me, to them. Have a good day, Judge Coffey.